The Supreme Court agreed Monday for the first time under its new 6-3 conservative majority to hear an abortion case, potentially threatening the long-standing 1973 Roe V Wade decision, which legalized aborting a fetus until 24 weeks, generally considered to be the stage of viability. The decision has already reignited one of the most contentious cultural and moral issues in America today.
There are millions of Christians like myself who are praying that the court will use this opportunity to affirm the state's rights to restrict the barbaric practice of murdering children in the womb.
And the president and the vice president are devoted to ensuring that every American has access to health care, including reproductive health care, regardless of their income, zip code, race, health insurance status, or immigration status. As such, the president is committed to codifying Roe, regardless of the unrelated, it's all related, but to the outcome of this case.
The case specifically challenges Mississippi's ban on abortion after 15 weeks of pregnancy. Both sides are projecting at least a partial erosion of abortion rights, given the court's conservative majority. Father Frank Pavone of Priests for Life told the Examiner, quote, "If you study the history of Roe v. Wade, you will see how arbitrary it was that viability was introduced. It was inserted rather superficially and arbitrarily. The Supreme Court ignored the science involved and most certainly the morality."
I think that's one of Mississippi's really strong arguments in this case. When you look at the timing they've chosen, 15 weeks, there's reasons for the protection of the woman, because after that, abortion is significantly more dangerous for the health of the woman. And there's also a lot of reasons for the protection of the child in the womb, because this is a point after which we know that babies can feel pain.
It will allow states to further restrict abortion. And so the best case scenario for people who are in favor of the protections on the right to abortion is a very narrow ruling in this case that upholds the central pedestal of Roe v. Wade and Planned Parenthood v. Casey and the actual right to access an abortion before viability.
But trying to project a justice's thinking, even the 3 recent Trump appointees, all vetted by pro-life interest groups, is a risky business. They generally pride themselves on independence and place great emphasis on precedence.
What would you say your position today is on a woman's right to choose?
It is an important precedent of the Supreme Court. By it, I mean Roe v. Wade and Planned Parenthood versus Casey. Been reaffirmed many times. Casey is precedent on precedent.
So if I express a view on a precedent one way or another, whether I say I love it or I hate it, it signals to litigants that I might tilt one way or another in a pending case.
Once a case is settled, that adds to the determinacy of the law. What was once a hotly contested issue is no longer a hotly contested issue. We move forward.
It is, however, not risky to project the political implications of the High Court taking up this case. The justices will hear arguments next fall, with a decision expected in June of 2022, just as the midterm congressional races are heating up, ensuring the decision could play a vital role in which party controls Congress. Doug McElway for the Washington Examiner.